We never know, right? So I'm trying to hopefully bring some conclusion today. So I'm going to ask, are you leading? Or Mr.
So there were two issues, clause 10 and clause 24.
Who's leading?
Mr. Edwards would lead on clause 10 in terms of the textual proposals based on the recommendation that we consider the obligation of secrecy preservations found in other legislations, such as the Bank of Jamaica Act. And then I will go on clause 24.
All right, so but there was a document circulated, and I'm hoping that all would have seen it. And this is a position that was the justification for the position taken. And I'd really like to recommend that those who may have an objection would refer to that document where they would see the reasons behind and the precedent and so on. If there is a case where we have to have a minority position, maybe we have to go that route, because I don't know. I mean, I don't want to preempt the process, but we've been having some conversations on this for a while. So we have to keep an open mind to this possibility. I've done some consultations myself, and I don't think it is attempting to have an imperfect document if there is an alternative view. And if the fact that we are going to several other chambers, the lower house, the upper house, for debate on the matter, also allows for a kind of alternative position. And this is allowed. So my view on it as chair is that even if there's a disagreement, there are avenues and other channels to discuss and to determine on whether a consensus can be had, absolute consensus or a majority position. And I believe that we have spent a lot of time kind of going over. There's a question about the document from Senator Golding, the one that was prepared. It was circulated.
Right. The responses were circulated from the day of the last meeting.
From the day of the last meeting, Senator Golding. I'm looking at your question. What document is the chair talking about? All right. Okay. All right. So, Mr.
Edwards.
Mr. Edwards, you want to start us off?
With clause 10.
Clause 10. Mr. Edwards?
Are you there? He is online.
I'm here. I'm just trying to unmute. Yes, I'm here. Thank you, Chair. Good day to committee members and all present. The ministry has had an opportunity to review the deliberations of the last meeting and is prepared to propose a text in relation to the matter of secrecy being the focus of the control in relation to somebody who was employed in the area of tobacco control policy and is no longer in that position. So this is in response to the concerns that have been expressed in relation to post-employment restrictions generally, as opposed to putting in a control that focused on the non-disclosure aspect, non-disclosure of information that would have been obtained while employed in the area of tobacco control policy. So we have done research and further to the Solicitor General's comments in the last meeting, we've looked at various pieces of legislation, primarily in the financial sector, Bank of Jamaica Act, Financial Investigation Divisions Act, the Financial Services Commission Act, and we have also looked at other more recent legislation dealing with the matter of protection of or secrecy provisions in relation to information that would have been obtained while public officers were engaged in such roles. So if I may, I don't know, Ms. Birch, is it possible to share the proposed text? Through you, Chair?
Yes, sure.
Yes, I think you could share it on screen.
No, do you have the ability to share? I'm not in a position to share.
Just a
Or if
minute.
not, if
Just
in
a
the
minute.
meantime, in the meantime, I'll summarize the approach taken. So the first thing is that we're proposing a formula that appears throughout the Jamaican legislation, where the first obligation is to regard, we're seeing the proposed provision. The first subsection is referring to the person who has had a role in the development or implementing of public health policy with respect to tobacco control, being obliged to regard and deal with as secret and confidential all documents or information obtained by such person in the course of the performance of their duties. There are some words there in square brackets, and this is because there is a standard requirement for public officers to abide by the terms of the Official Secrets Act. So this is why those words are in square brackets. They may not be necessary, but out of an abundance of caution, it's quite useful to make reference to the Official Secrets Act. So that's the basic obligation. Anybody who, as a public official, and then for the public official, of course, is not just the central civil service officer, but in the context of this legislation, it is broadened to mean other persons serving in public capacities. Now, the next provision is subsection 2, which obliges anybody referred to in subsection 1 who has communicated information to another person. So this is not a public official law. This is a person to whom information, that is the tobacco control policy information, has been communicated by the public official, is also obliged to regard and deal with that information as secret and confidential. And then the third subsection proposed is obliging the official to maintain the secrecy and confidentiality, not only while they are in the role, but even after they have left that role or the position has been terminated. So they're no longer in the position, but the proposal is that the requirement for secrecy and confidentiality be maintained subsequent to their departure. The fourth subsection proposed, I think we may have to just shift on the screen. Thank you. The fourth provision is, in a sense, the heart of the matter, because it is obliging any person, meaning the public official in office, any person to whom they communicated this information, and thirdly, any person who was a public official, who is no longer in that position. Any one of those categories, if you fall into those categories, you're obliged not to communicate or to attempt to communicate that information or anything contained in documents relating to the tobacco control policy to any person otherwise than for the purposes of the act, because there are going to be situations where you have to communicate information for the purposes of administering the law. And also, you may be obliged by court order to reveal information relating to certain matters on tobacco control policy. So these are exceptions carved out. Now, the next provision is seeking to provide a sanction. It's usually standard that when there are non-disclosure requirements in the statutes of Jamaica, that there is a sanction. But of course, we're ministry not in a position to specify the nature of the sanction, so that's why it's in square brackets. So that it essentially summarizes what has been proposed arising from the deliberations of the last meeting, that this appeared to be where the committee wanted to go in terms of post-employment restrictions, as opposed to the restriction on future employment. This restriction focuses on maintaining the secrecy and preserving confidentiality of information relating to tobacco control policy. Thank you, Chair.
Okay. Are there any objections or any comments?
Sorry, Chair. Can you just ask them to scroll up to the preamble? Thanks.
Okay, I see the hand of the SG. You can speak, please. Thanks.
Thank you. Good morning, Chair and members and colleagues. I just had one proposal, one amendment in 10.1 in the third line where it says has or had. I'm proposing that the words or had be removed because you have 10.3. 10.3 deals with when you had a role. If there's an issue with what I've said, I can give an explanation, a further explanation, but I don't think or had should be in 10.1.
All right, I thank you, thank you, SG. And I had anticipated that question, SG. The reason we had in two places is that the third subsection is seeking to deal with where the person essentially. Now I know we have to between the person who has left the role, meaning that they will be a public official, but serving in a different role. So they could have been in the
Sorry, excuse me, Chair. I'm not hearing Mr. Edwards. I'm not sure if the fault is on my end.
Not hearing him either.
Edwards, you're breaking up a little.
Oh, okay. It could
We're
be.
hearing you now. Go again. We're hearing you.
Thank you. So it was really a belt and braces approach, Chair, and in particular SG. We didn't want to only appear to be dealing with the person who was moving between roles and still a public official, and it's not clear that if they have moved from one role to another, whether it was also going to be clear that we wanted to keep the person who was no longer a public official at all. So, but if it is felt that 3 covers both, then we are happy to take out those 2 words out of 1.
Chair, if I may, the concern I have with leaving the words or had in 10.1 is that there could be an interpretation applied that could then engage section 1610 of the Constitution that says no person shall be held guilty of any criminal offense on account of any act or omission which did not, at the time it took place, constitute a criminal offense. No, the offense is to be prospective, and we don't want any interpretation that would make it seem as if it is retrospective or could apply in a situation where it was not an offense earlier. So I think 3 would have to, I think you should rely on 3 to deal with meeting your objective. I think or had in 1 could then perhaps lead to a doubtful interpretation, and you could have a problem with that.
All right, so
Okay.
I have no issues. I have no issues with that as long as it's covered. I think that's
Yes.
something I can yield on. Any other comment? Any other comment?
Chair, just not necessarily directly related to this point, but just asking whether or not the obligation to keep secret documents obtained in the course of the performance of the duties. Is there any place in the framework of this bill, or generally speaking, where those matters become public information? If people have the duty to keep it secret, I mean, we're concerned here mostly with persons working in the ministry or in tobacco control policy disclosing information, but is there anywhere where that information will be accessible by the public at some point in time?
Ms. Edwards, is there a
Can I
Yes.
respond? Okay.
Go ahead.
Just,
Go ahead,
Yeah, SG, yeah.
SG.
No, I'm
Okay,
yielding to
just-
SG.
okay,
All
just
right.
to say that the Access to Information Act will always apply. And in fact, we have at least one decision, well, two, from the ATI Appeal Tribunal that doesn't always take into account secrecy provisions in other acts. And there are times when the ATI Appeal Tribunal will rule, having regard to Section 3 of that act, in terms of a public interest disclosure outweighing other factors. And so it is possible that it can be released under the ATI Act. I am also aware that although you will have these types of provisions, sometimes there is a government policy coming from whether cabinet or minister that you start releasing information, data on a website. I think though that I don't know if we need to build in here that if the information is now publicly available, that it clearly would not be an offense. Perhaps that could be considered. And I think there is a provision in the ATI Act that perhaps could assist with that. So I'll just find that section and look to see if maybe it can assist.
Thank you for that, SG. That was
Exactly.
actually going to be my next question, because obviously when we do draft confidentiality provisions, certainly in contract, there's always the exemption for any penalty for disclosure where the information didn't come from the person, it came from an independent third party or from the public domain generally. So yeah, I think that would be a good idea.
Okay, thank you very
If
much.
I-
So
If
Dr.
I may,
Yeah, go
Chair?
ahead, Ms. Edwards. Yes.
Yes, thanks. It was just to indicate, and thanks to SG, that's where I was going, the ATI Act. And also, that's why we have a carve out in subsection 4, if it can be, if the document, if the text can be just scrolled up. That's why we say for the purposes of this act or any other enactment. So that is to give the opening for where, by virtue of any other enactment, you are allowed to disclose the information, such as
Thank
the
you,
API.
thank you, Ms. Edwards. Dr. Longmore, your hand is up.
Thank you, Chair. I just want to go on record to recognize my agreement with this approach. I think that we have gone through thoroughly and have come to a workable solution. Especially Mr. Edwards drafting from what pre-exists in similar situations in our legislation. I think that we now have something that can hold up to whatever questions as to constitutionality, etc., for this aspect of this legislation. So just want to bring that to the floor, that I'm personally very happy with this approach that we're taking. Thank you.
Okay, thank you. So ladies and gentlemen, if we are agreed on the approach, subject to the minor clarification that the SG has committed to examine, I think we can proceed from this this clause. And I want to thank the efforts of all who have been a part of it, interrogation, research, and otherwise. Thank you very much. Can we, yes, SG, you're gonna do the clarity
Yeah,
now.
well, so I think the issue would be in 10.4 that you would say that the person, I'm not sure how we would do it because we don't usually, we have not done it in any other law, but I don't think it would hurt. So it's either that it could be a defense for the person to show that the information was in the public domain, or we make it another type of exemption.
Okay.
But
Okay, is that
I'm not sure, I'm not convinced that we really need to do it, but
that was
Yeah.
my thought was that if the access to information allows, I just wondered whether or not we need to go there.
right. And the ATI Act already speaks about that, about information.
I don't think we should.
Sorry,
Yeah,
Chair.
let's leave it.
I don't think we need to.
Let's
Sorry,
leave it.
Chair.
Let's leave it as is. But I see
Sure.
member guy wanting to come in. I don't know why you're not using your hand, raise hand, member guy. Your computer.
I suspect that you might be offended by how I raise it, Chairman. So
No, it's fine. We're not easily frightened. Go ahead.
And I was being more frightened, you know. I'm just to say I agree with the position of Senator Longman. I think this particular position, as indicated by Mr. Edwards, is to my mind acceptable.
Okay, excellent.
And I too share the views, Chairman. I don't like to put the burden of proof on the individual in this case, because that might be too extensive a demand. So my preference is for where it is now.
All right. I want to thank the committee for this unanimous position. Mr. Edwards, you don't need to talk if you're going to repeat anything that is, I see your hand up.
No, it's not a repeat here.
Sorry.
No, it's just to settle the question of the proposed penalty. Is the committee prepared to, or SG, in terms of what kind of sanction? That's the only question.
I think the committee, sorry, Chair, I apologize for not putting my hand up. The typical amount is $1 million, and I think 6 months.
Yeah. Can we just put that there, Mr. Edwards, and agree to that?
Yes, we will incorporate that. Thank you, Chair.
Great. Thank you very much. All right, I think we're good here. Can we move on to the next, which would be now Kadian Birch, Miss Birch?
Okay, so this is in relation to clause 24, the tobacco advertising, promotion, and sponsorship ban. So at the last meeting, we would have circulated the ministry's technical position on whether, in our view, the clause 24 is constitutional. And the committee would have also heard the concerns of the Solicitor General in relation to the clause. So I believe, Chair, it's a matter for the committee to
You want to
indicate.
spend 2 minutes to go where you are and what the general conclusions are of the committee? A few minutes, you don't have to read the entire thing. It was circulated. The members should have it.
Okay. So we would have already gone through the data last week. The last meeting would have had the presentation from NCDA. And so we had outlined our legal considerations of the matter at section 5 of the paper, page 10. We considered whether the comprehensive ban on tobacco advertising, promotion, and sponsorship could be justified under Jamaica's constitutional arrangements. We set out that the provision in clause 24 of the bill, we accept, may infringe upon the constitutional guaranteed right to freedom of expression, as well as the right to seek, receive, distribute, and disseminate information, opinions, and ideas through any media. And this was affirmed in the case that the Solicitor General had referred us to in the Attorney General of Canada versus JTI McDonald Corp. That this right extends to commercial expression. As we are aware, under Chapter 3 of the Constitution, the rights guaranteed thereunder can only be limited if it is shown that it is demonstrable, justified in a free and democratic society. We looked at the test applied by the court, the proportionality test sets out in R.V. Oakes, and which was articulated in the case of the Attorney General versus Julian Robinson. And the 4 criteria that was set out outline that A, the law must be directed at a proper purpose that is sufficiently important to warrant overriding fundamental rights or freedoms. The measures adopted must be carefully designed to achieve the objective in question. That is to say, rationally connected to the objective, which means that the measures are capable of realizing the objective. If they are not so capable, then they are arbitrary, unfair, or based on irrational considerations. C, the means used to achieve the objective must violate the right as little as possible. D, there must be proportionality between the effects of the measures limiting the right and the objective that has been identified as sufficiently important. That is to say, the benefit arising from the violation must be greater than the harm to the right. We outlined that in criteria C above, Justice Stice in the Julian Robinson case stated that if the consequences of the measure on individuals or groups are very severe, then the objective must be shown to be of great importance in order to justify the severity of the consequences. And if this is not shown, then the law will be unconstitutional. He postulated that it is at sea that one finds the courts engaging in a balancing exercise. And what is to be balanced? The balancing act that is done arises because on the one hand, there's a limited law, and on the other is the constitutional right or freedom. The court takes account of the benefit to be gained on one hand and the harm on the other. What this requires an assessment of whether the benefit to be gained by a violation is outweighed by the severity of the harm to persons. If the harm caused is greater than the benefit, then the law is unconstitutional. And this component is asking that there be a proper relationship between the benefit to be gained and the harm to be caused. We also looked at the Jamaica Bar Association case versus the Attorney General, in which Justice McDonald Bishop endorsed the modification of the minimal impairment criteria that was exposed by Chief Justice Dickinson in R.V. Edwards Brooks and Art Limited. Justice McDonald Bishop took the view that since the essence of the proportionality test involves a balancing exercise between the rights of Parliament to make laws for the peace, good order, and government of the country, and the rights of individuals to protection from state intrusion, it seems justified that some latitude is accorded to the exercise of parliamentary discretion. The modified Oak test that the law must infringe the right as least as is reasonably possible is endorsed as a better approach. We outlined that in the Jamaica Bar Association case, which was appealed to the Privy Council, where the question before the court was whether certain aspects of the statutory regime in Jamaica for combating money laundering in its application to attorneys at law violate without demonstrable justification certain rights guaranteed by the Jamaican Constitution so that they should be declared void. And this case concerned provisions of the Proceeds of Crime Act, in which the Jamaica Bar Association contested would violate for them or for their clients the guaranteed rights of privacy, liberty, and freedom of search. In this case, their lordships noted that in considering whether a less intrusive measure could be used, the need to allow the legislature a margin of appreciation is of particular importance. Lord Reed explained in Bank Millet versus His Majesty's Treasury, in relation to the third of these criteria, Chief Justice Dickinson made clear in R.V. Edwards and Brooks and Art Limited that the limitation of the protected right must be one that it was reasonable for the legislature to impose. and that the courts were not called upon to substitute judicial opinions for legislative ones as to the place at which to draw a precise line. This approach is unavoidable if there is to be any real prospect of limitation on rights being justified. Justice Blackmun once observed a judge would be unimaginative indeed if he could not come up with something as a little less drastic or a little less restrictive in almost any situation, and thereby enable himself to vote to strike down legislation down. Especially, one might add, if he is unaware of the relevant practicalities and indifferent to the considerations of cost. To allow the legislature a margin of appreciation is also essential if a federal court system such as that of Canada or a devolved system such as the UK is to work, since a strict application of the least restrictive test would allow only one legislative response to an objective that involves limited or protected right. And so in the Jamaica Bar Association case, the committee rejected the argument of the Jamaica Bar Association that a less intrusive measure such as disciplinary proceedings could have been imposed on attorneys under the proceeds of crime regime. It was noted that both international and national disciplinary regulations were insufficiently addressing the issue of facilitation of money laundering by lawyers, and the committee formed the view that further steps would have been needed in the interest of effective detection, prevention, and enforcement, and the act of making the regime part of the criminal law was within the legislature's margin of appreciation. And so the committee concluded that actions beyond what was considered less intrusive were within the range of reasonable options open to lawmakers to consider. We also looked at the Dayton Campbell, the recent case of the Dayton Campbell versus Attorney General. And the court...
Sorry, excuse me, Chair. If I can just make a comment right here. The government has appealed that decision, and we're actually before the court also requesting a stay of that decision. So I'd prefer if we don't rely on that, on the Dayton Campbell case, please.
Well,
Okay.
does that mean that you are...
We're before the court requesting a stay of the application of that decision because we have many other matters filed with the same type of allegations. The claims are very similar.
Okay.
So not only are we appealing it, but we have asked for a stay of the implementation of that. We're challenging that decision. So I would really prefer if we don't, if it's not being discussed.
Okay.
All right. You have any other point to raise?
Right. So we, based on the cases that we examined, both in our recent response and also our 24th of November 2023 letter, which was also shared, we believe that we're of the view that there's cogent local, regional, and international scientific and economic evidence to support the justification for this ban.
Mm-hmm.
There is a preponderance of evidence which shows the effectiveness of comprehensive bans on tobacco advertising, promotion, and sponsorship in reducing tobacco use, in particular, the recruitment of new users of tobacco. And there's a wealth of evidence which shows that restrictions on tobacco advertising, promotion, and sponsorships are not very effective. We had outlined in our previous letter of November 23rd, we had looked at the case as research paper that was done that looked at the implementation of a comprehensive ban on taps in Uruguay and in Argentina with a partial ban. And in that study, in Uruguay, it was noted that the complete taps ban, which included standardized tobacco packaging, maintains high compliance and severely limits exposure of tobacco advertising, promotion, and sponsorship, despite a few problems with corporate social responsibility and social media. However, in Argentina, that had a partial ban or a restrictive ban, they had more problems with compliance and exposure to taps. And so the case for Uruguay was determined to be a model for the region, both in terms of banning tobacco advertising, promotion, and sponsorship, and advertising on cigarette packages through standardized packages. Overall compliance was noted to be high, and their early evaluations indicated success in terms of limiting the exposure to taps. It was noted that tobacco companies, they use taps as a form of recruitment of new smokers. And therefore, as this was crucial to the survival of their industry, their strategy employed is to target their main customers, that is young people who are more susceptible to starting the habit, and women who use tobacco less frequently and therefore constitute an attractive niche. And it's important to note that the tactic of targeting specifically young persons is to ensure that they can to ensure addiction, which would allow for the lifetime use of this product. And so there is indisputable evidence that tobacco advertising, promotion, and sponsorship activities increase or sustain tobacco use by effectively recruiting new tobacco users and discouraging current users from quitting. And so while we acknowledge that the Article 13 of the Framework Convention of Tobacco Control indicate that a party that is not in position to undertake a comprehensive ban due to its constitutional principles shall apply restrictions on tobacco advertising, promotion, and sponsorship. Our position as a technical team is that we believe, based on the cases that we have examined both locally and internationally, that the comprehensive ban is constitutional and would be able to withstand any challenge that may be raised regarding its constitutionality, given the local evidence of tobacco use as well as international evidence in terms of the effect of tobacco advertising, promotion, and sponsorship on tobacco use. And given that the objective of the Act is to reduce tobacco use and to protect the public from the perilous effects of tobacco use and secondhand smoke, we are of the view that the comprehensive ban is what is required to meet that objective.
That's it. All right. I wanted to ask again, just for the purposes of all here, what's the difference between a partial ban and a comprehensive ban on advertising? What does partial represent? Anybody can help me with that?
So we would have circulated a matrix, Minister, yesterday that looked at comprehensive and restrictive. So in comprehensive, all advertising, promotion, as well as sponsorship, without exception, would be banned.
So right now, when I go to the service station, I see something behind the cashier with the name of the brand on the box. But really, it's really a point of purchase kind of thing, but it's really on the box as opposed to anywhere else. Would that be considered a partial ban or a full ban? What would a full ban represent in a case like that?
In a case like that, display of the tobacco products or relevant products at retail point of sale would be banned. So they have to keep it away from public view. So what they would have would, let's say, for example, a list of the tobacco products available, but it wouldn't be on display at the point of sale for you to see and to.
So people would have to ask for it.
Yes.
So they would have to ask to say, okay, I want a box of X versus I want a box of Y brand.
Yes.
And how would they know that Y and X brand exist in terms of, like, I don't know what these brands are, but I guess you have a couple of different brands. So how is there any name on that, or they would just have to know? How would they know?
Well, they would, because we haven't adopted plain packaging. We
Right.
have graphic health warnings, so the box will be there with the information.
Okay.
But it wouldn't be available on display for somebody to go and choose and say, or be persuaded by what other information may be on the box.
Right. All right, because I mean, I want to be clear that the concept of advertising the product or promoting the product under any circumstances can't be, should be restricted or not allowed. The issue becomes identifying the product, meaning information purposes. If you have brand X, brand Y, brand Z, how do you know that it is brand X, brand Y, brand Z? I don't know. I mean, that in other words, is it that no other brand could be created because people would not have knowledge of those brands, only those that are already there? All right, I see a lot of hands up. I want to take it in order. I think the Ms. Birch has presented the case for comprehensive as opposed to partial. Because a nuanced definition of what comprehensive represents and what partial represents. Still want to try and understand a little better. While I do agree that the obvious format of promoting and advertising, I would be very much opposed. All right, so I see Member Gail, then SG, no, then Member Guy, and then we go to SG. Member Gail?
So, Chairman, I wanted to make the distinction between you advertise and you promote as part of a campaign. But if it's, how do you treat with displaying the product where it is being sold? Because you may go into where the vendor is and you're not seeing the product. Is it that it can't be displayed in a full ban? So you're not seeing it on a shelf. You're not seeing it in a glass case. You're not seeing it nowhere near the counter. Does that constitute the full ban? And what is the objective that we're seeking? I guess the chairman left, so he does not want to display.
Perhaps there was another fire alarm.
Oh, another one?
Perhaps I'm just speculating.
What was the question?
Yes, I was asking, just to qualify in my mind, the distinction between the advertising, the promotion, the marketing, as opposed to display. And if you go into where the vendor is, whether the product is displayed on a shelf, on a counter, in a glass case, what is...
We lost it there, Member Gail, but I think I understood what you were saying.
Oh, okay.
So you're trying to narrow the focus around the definitions.
Yes. And just to identify which one of the objectives that we are seeking, is it a total that includes non-display?
Right. So those comprehensive ban mean non-display?
At points of sale.
At points of sale?
Yes.
So where would it be displayed? On the counter somewhere in a cabinet where it's not seen and then people have to ask for it?
Yes.
Okay.
So back to the question that you had asked now between product A, B, or C, because you may know a product, but the availability to another one, if it is not seen, it is not displayed, then the consumer may not have a choice.
So the issue becomes, how would it be that a list of product A, B, C is put up somewhere and people say, okay, give me product X versus product Y versus product. And if that is the case.
What's the difference between product A and product B? In terms of imagery as opposed to a name?
Is it less of an incentive to purchase if a list is displayed behind the counter as opposed to the actual box? Is that what we're arguing?
Right. So for persons who are already smoking, they will know their products, and if there's a list, they can inquire for information to be shown. But what the objective is that you do not have it displayed at point of sale where it persuades you
Right.
Or
So,
it
right.
gives the impression that
So,
it is
so what
socially
is,
acceptable.
I'm coming to the others who have their hand up. Please indulge me just for a little bit. So I'm just saying then, because I think the clarity is important, that what we're saying is that there is less of an incentive to purchase if the product is not physically displayed, but maybe a list of the products
Prices.
where people would still have enough knowledge to know that this is product X, Y, Z, and they say, give me X, and X is taken from under some, out of some cabinet or something. If that is so, and the argument is that physical display may be also considered an incentive that would encourage purchase. And we're trying to minimize purchase as best as possible. Is that the kind of appreciation for what
But
we
minimize use, so where it would
use? But yeah, use by purchase, not free. Yeah. Yeah. All right, member Guy, then who else? SG.
Thank you, Chair. My view is that the point that is just being discussed basically suits what the committee should be looking at. The intent is a total ban on cigarettes eventually, or tobacco use eventually. Now, if there is less promotion of the various products or even the product in the marketplace, then there's less likely that people would be, or even new users will be wanting to see what's the difference between one or the other. So it is basically supporting the point that, or the position that we would like to have eventually, where there is no use of tobacco or tobacco products. So I wouldn't have a difficulty in respect of this having a total ban. I understand the differences, but I mean, I'm not particularly swayed to the fact that we would need to have a sign up or something indicating what the various brands that are available here and the cost of them. No ban, I mean no advertising, no promotion. And that is, to my view, that should be acceptable.
Okay, great. Thanks for that contribution. SG and then Dr. Longmore.
Chair, I don't mind going after Dr. Longmore because I'm gonna say something more technical.
Okay. Sure. Thank you. Senator.
Thank you, Chair. I too will raise something a little bit, just going a little bit back to the constitutionality argument. I think we should also bear in mind, if the challenge were to come, we are speaking about something that removes free choice. So in all aspects of consideration of the Oakes test, in terms of whether or not it is present and substantial, rational connection, we have satisfied those. Minimally impairment on the industry and proportionality. All the cases that were brought that has had rulings that we have considered that was brought to the floor just now, we're considering cases where the freedom of choice still exists with the individual. This substance removes freedom of choice. That is the nature of the addiction.
How does it remove freedom of choice?
Because the addictive potential, the demonstrated addiction and the results of the addiction is what the individual faces. So they no longer, when they go and they are stimulated.
Okay, I get the point you're making. I get the point.
Okay. All right. So you have the pregnant woman who knows it is unhealthy for her to smoke, but she's still lighting up and telling the doctor that she's going to go and asking with tears in her eyes that she needs to stop smoking, but she cannot because of the addiction. And that is what I'm bringing now. Oakes test and all did not consider, or in this case, the addictive nature that removes free choice. Lastly, just to add now, regarding the display and the level of restrictions we want to have. Again, because of said addiction, the person going to purchase a pack of cigarettes knows what they want. It is very unlikely that someone will go to a gas station and be purchasing a cigarette for the first time in that space to make a choice. So I think a list indicating what products are available, the price of the products, the person already is in the habit and will be purchasing what suits them with their past knowledge and awareness. Thank you, Chair.
So from your perspective, particularly, and it's a unique perspective at this table because you treat patients, I would imagine your profession, that have addiction issues, and you are making that case that it kind of overrides the traditional approach to freedom of choice and that the right to freedom of choice. That's one. And then secondly, your interpretation of the ban would be the comprehensive ban, essentially, just as Dr. Guy is saying. That's my understanding. I mean, an information sufficient to know that the thing exists.
Yes.
And people can ask for it, but not to be, but minimally any persuasive posture or positioning of the product.
Yes.
That would encourage. I think that that's kind of encouragement in these stores from anyway. All right, fine. Madam SG, you want to
Chair, before SG comes in, I beg you.
Yeah, no, I'm
Because-
telling her that I'm going to point to you first and then she can come in.
Thank you.
Go ahead.
Because what I wanted to know so we're talking about the fairness to the consumer now and the right for information. And I'd want to know how does this objective intercepts with the Consumer Protection Act?
Okay, so you're asking a question. All right. I don't know if anybody here can answer that. Mr. Edwards or Ms. Birch. The Consumer Protection Act gives a protection of the consumers, I would imagine. And that could be from addiction or addictive substances, but I'd allow the lawyers to give a perspective on that. Mr. Edwards, you want to say something?
Yeah, just briefly, Chair, in response to Senator Gill. The Consumer Protection Act will really be focusing on the issues of accuracy, fairness, and not misleading. So the fact that an item may not be on display is not necessarily affecting the right of the consumer to be treated fairly, to not be misled, and to be given sufficient information about the product. It's just that the product won't be in your face, but the seller is obliged to be accurate, to give you fair information, and this will of course include information as to the challenges of
The contents of the product and the effects of the product itself.
Yes. So the fact that it's not on display does not negate the obligation of the seller to be fair and thorough to the consumer and not mislead the consumer as to what they are seeking to purchase.
All right. Thanks, Mr. Edwards.
Okay. All right, SG, your time.
Thank you, Chair. Just in terms of that list that has been discussed, looking back at the language of clause 25(1), where it prohibits all advertising and promotion, it is possible that the list could also not be displayed, but it would not stop the seller from having a list which is kept, let's say, behind the scenes, that can be produced, that will show the list of which will identify the product and the price. But I am, based on this prohibition, I am not convinced that that list could also be on display. Just to make a very technical comment, as it relates to the Privy Council decision for the Jambar case, the issue about the minimal intrusion was the fact that there really was no there was nothing that could have been done in a minimal manner that was recognized by international law. So when the argument was made on the other side, they did not have support about a minimal intrusion to the right. And in fact, the court would have then had to make law, make it up. In this situation, it's different in this situation where the convention already gives you less than prohibition. That was not the case in the Jambar situation. There was no less than. It was an outright one situation, and there was nothing less than that could have been relied on by the Jamaican government. So I just wanted to make that distinction. So it's not really on all fours.
Okay, thank you very much. All right, so.
And Chair, sorry, just to interject there, that is why I made the point around free choice and the minimal invasion, because the industry removes free choice. The nature of the industry removes free choice from the individual.
Right.
So they're not considering minimal invasion on the individual. Just to
Right. No,
to bring that point.
And I think your point was a strong point, and it was supported prior to your coming in by the other medical practitioner on the team, member guy. I think, if I may be so presumptuous to say that the issue around freedom of choice is overtaken by the addictive nature of the product and the precedent that has been established in other jurisdictions around making that point and providing evidence to support that fact, that reality. The distinction as it relates, and I really think we all have to, well, I can't force anybody, but I think there is general agreement on this, certainly by virtue of what has been said so far by members of the committee, and by the reports that we have seen. The issue as to what constitutes a comprehensive ban as opposed to a partial ban is I think where a decision should be taken. I think we're all agreed that none of the traditional types of promotion, advertising, displays should be allowed. And I think there is ample precedence for that. And it doesn't fly in the face of freedom of choice because of the reasons given prior. I think the issue of the behind the counter, out of sight positioning seems to be a generally agreed position. The SG, who I am pleasantly surprised at, gave good advice. I think she normally does, by the way, just for the record, that there is no injury done to requesting a list as opposed to displaying a list. And that for me is quite noteworthy. And therefore, we could be even more extreme on a partial position of a full ban by having a note to say, if you're interested, ask for the list or something like that, or people asking for the list. And then a list is provided and they make a decision, which would make it a lot more one-on-one kind of personal, as opposed to any side effects, if you will, of putting something on display and it generating the curiosity of a youngster coming from school or maybe over the age, but still curious because they haven't tried it yet and wants to try it. So it seems to me now it's a decision between, do we have a display that say this is here and these are the things that are your product XYZ, but not the actual product? Or do we have a list based on demand or inquiry where that list can be provided? And I'm asking that we narrow the conversation to those two things and make a decision on that, if I, again, to guide a conclusion. Now, again, you know, these things are going to be debated in the Senate, in the upper house, lower house, and there's ample opportunity for everybody to voice their views on it. But I really think we should really try and make a decision now and advance it to complete the report. Anybody wants to comment on that? I mean, if I had my way, you know what my decision would be, but I'm trying to be all inclusive. So what say you, members? Okay, nobody?
Can you repeat again your all-inclusive approach, sir?
My all-inclusive approach is to get your opinion. Whether or not we say that there is a notation for public viewing that product XYZ exists, but not the product itself. So the product doesn't become part of the temptation, which is indirectly a kind of advertising. Someone would then see that XYZ exists and ask. Or, as the SG says, you ask if the product exists because you already have an appetite for the product. And that list is provided to you and you determine what you want. So there's a list, but that list is not on display.
So in the first instance, if you have the list on display, it could provide a vendor with an option to say, we sell A, B, C, D, E.
Right, right.
Which would be, again, a kind of marketing.
Okay, fair enough.
You're not seeing the image of the product.
Right.
But there lies that we have all these suites of product who are a part of a family together, available.
Right. So I take the point. That's what I wanted to hear. So you're saying, let the person who have the appetite come and request the list.
Yes.
Member Guy, what's your point? Your point?
Well, you know, Chair. Every retailer has a list of things they sell. I wouldn't have a challenge with the retailer having a list under the counter or somewhere or hidden. This is what we sell. So anybody who comes in and asks, what do you have here available? You can produce it and then show them and then put it back away from public view.
Okay, excellent.
So I'm agreeing with Senator Joe.
Right. That's my position too, by the way, but I wanted somebody else to say it for fear that I'm trying to influence, although maybe that's part of my role. Is there any other comment?
Well, you just put it back under the counter.
All right. So if is there any other comment on that? Because if that is an agreed position, the question is how we frame that in the document as part of the proposed legislation, or is it already? In other words, that would constitute a comprehensive ban, right?
Right, a part of it. So it speaks to not initiating any advertising and promotion or sponsorship, not producing or placing any advertising or sponsorship of the tobacco product, and it includes what we're discussing in terms of displaying the product at.
So it's already captured.
Product at retail point of sale.
You want to read that back then? Okay, hold on. I see Dr. Longmore. I just get ready to read back that section first.
Thank you, Chair. I'm giving it great thought. I think I'm very clear regarding the advertisement and promotion and so forth. But in terms of the minimal impairment for the industry players in the sale of their product, would we be overreaching in them, the product not being available for obvious purchase to the consumer? It's a very delicate balance, and yes, this is coming from me, but I'm trying to be reasonable to the players in the industry, because
you're becoming a walking contradiction.
No.
Let me tell you why I say that. Because on one hand, you're saying that the addictive nature of the product.
But Chair, hear me out. Hear me out. I know we're pressed for time, but hear me out. What I'm trying to make sure is that we find a balance that the industry does not have a footing to challenge our decision or our recommendations. That's what I'm trying to ensure. So
Yeah, go ahead, sorry. Go ahead, finish your point, sorry.
No,
Finish the-
I am thinking that the list of the product should be visible, that the persons can see what is available, but not necessarily the product itself. So
Right.
the individual should not have to ask, but the list we have available, or the following whatever is available for purchase. Simple.
All right, a couple of points I make to that.
Okay.
Firstly, I repeat what I had said earlier, that your argument was most compelling about the addictive nature and the fact that people
It is.
will ask anyway, and we want to discourage ask. What we're trying to discourage are those who are less inclined to ask, and visibility may actually initiate possibility of asking. I think Minister Member Gale's position about it still representing some form of
promotion
is also a good one, and true. And I think that the point on the industry likely challenge is going to be there anyway, because that's normally what they do. So we just have to prepare ourselves for that. And sometimes maybe it's at that level that a decision perhaps is best made. So I would be inclined to go with Member Gale and Guy, and since SG does not seem to have a problem with it in terms of legal grounds, I think we could go with that and then allow the debate to rage on in the Parliament and if necessary beyond. I have never approached this, ladies and gentlemen, members, this responsibility as one that is going to be not challenged in some way, shape, or form, or even criticized, because the nature of this product and the approach to regulating it is kind of an outlier when you look at precedents around the world. It's not similar to other products and other industries. We must accept that. And the extent of challenges are also fairly unprecedented when you look at the global benchmark. So my position is we should prepare ourselves, but we should allow our conviction to guide from a health perspective and try to ensure that, of course, the legal framework is sound enough to deal with those challenges when they come. Madam SG, your hand is up.
Yeah, I just want to clarify. My comments were just to try and assist the understanding of a comprehensive ban, which would be if you're really going a comprehensive ban, you cannot have the list up for display. It doesn't mean that this is an approach I agree or not. I'm just here to provide legal advice. Because the other options are actually less than the comprehensive ban and would fall under Article 13.4, which is restrictions, not the comprehensive ban. So I was just trying to clarify. A comprehensive ban would mean that nothing can be displayed, because anything displayed could be considered to be either promotion or advertising.
Right, and we made that point. So, and we accept that clarity. So can you read back the section for us, please, and let us see if we can bring some conclusion to this.
Okay, section 24, subsection 1, all advertising and promotion of tobacco products or relevant products or tobacco sponsorship is prohibited. Subsection 2, without prejudice to the generality of subsection 1, no person shall initiate any advertising and promotion of tobacco products or relevant products or tobacco sponsorship, produce or place any advertising and promotion of tobacco products or relevant products or tobacco sponsorship content, display any advertising and promotion of tobacco products and relevant products or tobacco sponsorship content, including tobacco product display or relevant product display at retail points of sale, disseminate when the person is aware or is in a reasonable position to become aware of any advertising and promotion of tobacco products or relevant products or tobacco sponsorship content, or engage or participate in any advertising and promotion of tobacco products or relevant products or tobacco sponsorship content as a media or event organizer, celebrity or other participant, or as a recipient of any sponsorship contribution or intermediary that facilitates any such contribution. 3, the prohibition in subsection 1 includes any advertising and promotion of tobacco products or relevant products or tobacco sponsorship that promoter is likely to promote the tobacco industry, whether directly or indirectly. 4, where any person who has management or control over the publication or dissemination of content through analog or digital media or communications become or reasonably should be aware of any content prohibited under this section, that person shall remove or disable access to the prohibited content. 5, the prohibition on advertising of tobacco products, relevant products, or tobacco sponsorship shall not apply to the following: depictions of tobacco products or relevant products or their use in media where the depiction is purely incidental or is justified by reasons of historical accuracy or legitimate journalistic, artistic, or academic expression. Political, social, or scientific commentary about tobacco products or relevant products or their use. Reporting of information that is necessary for business administration or for required corporate reporting. Products information made accessible to persons within the tobacco industry who require the information for trading decisions and only to the extent access is limited to those persons. And a tobacco manufacturer's newsletters destined exclusively for manufacturers, employees, contractors, suppliers, and business partners, and only to the extent access is limited to those persons. No person shall employ any means with respect to any of the items listed in subsection 5 that are false, misleading, deceptive, or likely to create an erroneous impression about the characteristics, health effects, hazards, or emissions of a tobacco product or relevant person. No person shall receive any payment or other consideration from a person operating or employed in the tobacco industry or any person acting on behalf of or in the interest of the tobacco industry with respect to any activity under subsection 5A and B. The minister may prescribe additional requirements, conditions, and restrictions in relation to subsection 5. A person who contravenes this section commits an offense and shall, on summary conviction before a judge of a parish court, be liable to penalties specified in the 5th schedule. Without limiting in any way the broad application of this section, the 4th schedule provides a non-exhaustive list of examples for illustrative purposes only of prohibited advertisement and promotion of tobacco products and relevant products and tobacco advertising. The minister may, by order published in the Gazette, amend the 4th schedule.
That's it?
Yes.
SG, you want to come in and then Mr. Edwards?
Yes, just from a drafting perspective, since there are exemptions to the prohibition, I think the, clause 25(1) should refer to that. So it just says all advertising and promotion and sponsorship is prohibited, but that's not quite so because there are exceptions in 5. So I think it should say subject to. 25(1) should say subject to.
Okay. Fair enough. That's acceptable. Mr. Edwards, what's your point?
Yes, but I can just also agree that we will be prepared to review the wording of that provisions consequent on the SG's.
We have to do it now and read it back because we want to complete the document. So is it something you can do now and just reword that particular section, reread that particular section?
So in subsection 1, it would say subject subsection 5.
Okay.
All advertising and promotion of tobacco products or relevant products or tobacco sponsorship is prohibited.
Okay. So that's acceptable, Madam SG. It's included.
Yes, thank you.
Okay. All right. So, ladies and gentlemen, I think that would take care of the 2 outstanding sections. I need to be guided now as to where we go from here. I can tell you what my objectives are or is. I would really like us, if necessary, to round robin and sign off on the report before the end of the parliamentary cycle, which means trying to complete it, circulating it and get everybody's signature. And so whoever takes on this task after the next political cycle would have started, they have a report to take to Parliament, because clearly we won't be the ones, or maybe we will be in this similar form. Maybe it's a different committee, I don't know. But we have done a lot of work, and it would be a pity to not complete and not be able for it to be placed in the Parliament for debate, which would be the next obvious big aspect of the task at hand. So who wants to guide me? Is it parliamentary, Madam Parliamentary Secretary, or what? How can we move this process now to circulate over the next week, maybe to get everybody's sign off? Madam Secretary,
Yes, Chairman, I'm here.
what's the next steps?
So we would have to finalize the draft report,
Yes.
circulate, well, I'd submit to Ms. Birch for her review, and then we circulate to the rest of the members for them to review as well. Then
So
we
is it
can do sign off.
Is it a review with an appendix document list up for signature to say, okay, we agree with the report, or is it just a review? Or how does that process work?
So it will be review and signature once
Okay.
once there are no amendments.
Right. So I understand that there was an attempt at a document being crafted subject already. So it would be just these aspects that would have to be reviewed and incorporated. Is that so?
Right, so the Chief Parliamentary Council will update the bill,
Mhm.
given that we had agreed that we would seek to have the current bill
Right,
replaced with
right,
the
right.
withdrawn and then replaced with the updated
Right.
with the report.
But the report itself, was it a work in progress, meaning that you have the substantial aspects of the report and it's just a matter of adjusting for some of the changes that have taken place?
Right, so the clerk has updated the report
Right,
for
has been
every
followed.
meeting,
Okay.
so it would just be to update in terms of the inputs from today.
Okay.
And I believe circulate to the
All right. I
committee.
see
for
Mr.
their
Edwards
review.
and SG on a hand up. Who wants to go first?
SG, of course.
SG?
No, you could go ahead, Mr. Edwards. Your hand was up before mine.
Okay, sure. Thanks. So just a reminder, and Ms. Birch has indicated in previous meetings that substantial document that is to be appended to the report has been prepared in draft, which is the list of amendments to the bill. So that will be modified to reflect the latest decisions of the committee chair, but it has been substantially completed, the list of amendments.
How long would that take?
Mr. Edwards prepared the list of amendments, so it would be to update it with the.
A list of amendments?
List of the agreed recommendations. The
I thought the bill was
recommendations
going
of
to
the
be withdrawn and retabled. So in that situation, you don't do a list of amendments.
Yes, Chair, can I intervene, please?
but
Chair,
Hold on.
it really was a question that I was going to ask you, because given the stage of the committee, this report would have to be tabled both in the House and the Senate and debated to be approved. That's not likely to happen. So the report is really no longer a parliamentary matter. The report is now really a matter for the ministry to produce a bill reflecting the recommendations in the report, and in the new parliamentary term to have that bill tabled. Because once Parliament dissolves, this committee no longer exists, and this committee may not be able to be reestablished with the same constituent members.
Right. So I've said that. So what I was asking is whether or not the committee, as it now is constituted, can actually sign the final report, given the changes that have taken place up to this point, within the legal time allowed for a committee that is functional.
Yeah,
That's why I was asking the question.
yeah, we have to sign the report because if we're concluded and there is a report, then,
Yeah.
then we sign the report. But the problem what I'm suggesting to you is even with the signing, you have nowhere to put the report.
I know. I
So-
didn't argue for that. I just wanted us
Right.
to sign it.
No, we can sign, but we have to
yeah.
sign quickly.
It's just the pace. That's the
but-
point. That's exactly my point. All right, Mom. SG, you want to come in here or Mr. Edwards? You're Mr. Edwards.
As I'm looking back at the report, I don't see where the members have agreed that the bill that had been tabled, the proposal is to withdraw that bill and that a new bill would be tabled. That is, and I thought that was agreed,
That was agreed.
but I don't see it in the
Agreed.
report. So I'm saying that would need to go in the report. And in that situation, you don't table a list of amendments because that was the whole point. The reason you don't do a list of amendments is because it's so comprehensive that it just makes sense for you to have a new bill. And then in that situation, all you would now have is a report that says what we would be proposing is withdrawing that other bill and having a new bill. So all the members would really need to do is sign the report. There would be no appendix.
That is exactly right.
Well, I mean, you wouldn't have a list of amendments, sorry. Mhm.
That is my point. Just to clarify again, what I was seeking to do, which I said, was for us to sign off on the report. And I do recall in one meeting prior, a few meetings back, we had agreed that we would withdraw the bill and do a comprehensive, submit a separate bill. So I'm with you. So Mr. Edwards, this idea of the amendments would not apply in this case. All I was seeking to do is to get the members now to pen their signature to a report, because I think we have done enough work. It has been a real challenging process. You have all contributed, and I'd love to see it done within a period of time. Not necessarily for the bill to be submitted and certainly not tabled because it can't.
Chairman,
So-
can I just recommend
but-
one additional step after it is signed? That the report be formally sent on the cover of letter to the clerk.
Yes, of course, of
Right.
course. So can we be assured, Ms. Birch and Ms. Edwards, that the report reflects withdrawal of one and the tabling of another? Because we did say that would have been done. Is it in the?
Well, the
document?
committee clerk will note it to revise the report.
To revise, yes, yes. That was our understanding. Sorry, Chair,
Okay,
that was our
all right.
understanding. But Chair, I just wanted to indicate though that I am aware of situations where you have the report, the list of amendments, and the recommendation for withdrawal and replacement. So they're not necessarily in conflict. So I just wanted to indicate that I am aware of those situations where you have had a report, a list of what is called amendments or recommendations, which would tie into the replacement bill being proposed. Thank you, Chair.
All right.
I don't know if SG has another comment.
Is you had another point?
Yes, please. May I be permitted to just make an adjustment to what is on page 17 of the report, because I still have some issues with what is represented there as the comments made by the Attorney General's chambers, perhaps in maybe 2 sentences, and I could just send that. I can send it to the committee clerk and she can then circulate to everyone.
Would that affect us signing off on the report?
No, just that I want the comments that are attributed to the Attorney General's chambers to be accurate. That's all I'm asking for. And I can try and do that today. Not try, I will do that today.
That's very precise language. Thank you. All right. So, ladies and gentlemen,
Chairman, just for the sign off, because it's going to require physical signatures, and normally we would have the opportunity to be meeting. But now committee members are all over the place. So once the document is ready, if we could be notified, and if it means coming down to the House of Parliament to sign off, that might be an appropriate way.
that would be you.
Dr. Guy, you don't need to be all over the place. You can stay put.
I think that's a practical solution. So can parliamentary secretary take note of that, that position.
Chair,
right.
I just asking for some clarity. I'm trying to raise my hand, but it don't seem to be going up.
right.
What Mr. Edwards' comment was this last comment. So just to be clear, we are agreed that we're just signing the report. That report will go to the clerk, and there's no question about list of amendments.
No,
Very
because
well, thank you.
we're gonna withdraw the old
Right,
bill,
very well.
reflecting all that we have said. Okay,
Chair?
so yes, Mr. Edwards.
Chair, I just want to indicate that in the case of the, just for the record, in the case of the data protection bill, when the committee reported what they did, and I'm looking at the report, it said, in light of the number of amendments that are being proposed to the bill, we recommend that the bill be withdrawn and a new bill be tabled, reflecting the amendments as outlined in the list of amendments appended to the report. So that's why I'm saying the two are not inconsistent. That's
Right.
just what I want to bring to the committee.
Yeah, but we're agreeing that we're not doing that. Isn't that what you're doing, Chair?
Well, it could be, yeah, it doesn't mean, folks, members, colleagues, that there is going to be an attachment of the amendments. What he's saying is that the report is asking for a withdrawal and a new bill that will reflect the amendments that we have discussed.
That's not what I understood him to be saying.
But I'm saying so, and if there needs to be clarity, please reflect it in the report. We don't need to submit a list of amendments because we're going to submit a new bill. So just leave the report, keep it in Parliament. We ask each person to sign, stop by and sign, and we try to do that over the next week or so. All right. So if there's no objection to that, I want to close this very long session over these many years, I should say, by thanking all of you very much for your efforts. I know we all placed a lot of time, a lot of effort in coming to this point. We were disrupted somewhat by the COVID process, and so there is some good reason why it has taken so long, outside of just the efforts in trying to get it right. I am convinced that we all have done so in the spirit of partnership and trying to get the best result in the interest of the people of Jamaica. And even with our differences, I have no doubt that we, approach this matter in a very constructive way. So I want to really thank you. I want to thank the Parliament, and I'd like this to be reflected in the report, by the way. The Parliament for their efforts. We have had a lot of challenges with the Zoom meetings, and because of course of the challenges of COVID, we were able to survive that and have continued that, and it has taken extra effort from the Parliament. So please thank them, and I'm thanking them on behalf of the members and the members who have made the effort despite so many other issues. Thank the AG's office through the SG for her consistent presence and participation and technical feedback. We appreciate it, madam. And thank the stakeholders who have contributed to this discussion, those who submitted papers, positions, those who were present, the Pan American Health Organization, Mr. Stein and his team, who else outside of the SG's department was there?
Legal
reform,
Parliamentary Council.
And Parliamentary Council. Just for the record, I want to thank them and really thank all of you. I mean, it's been a real long process, I know, but I think it was worth the effort. So we look forward to the report now being signed off on, and then in a new dispensation, in keeping with our political cycle, we will tackle the issue of the bill, the new bill, and then the debate, which hopefully will lead to a framework that gives adequate protection to the population. Thanks again. God bless, and enjoy the upcoming independence season and any other season that is usual in these times. Keep safe. Thank you very much. All the best.
Thank you all. Thank you, Chair. Thanks, everyone.
Take care, everyone. Bless you all.
Take care.
Bye.
Right all.
Mosquito breeding. Mosquitoes will breed in any container that holds water.
Tightly cover water storage containers such as drums, barrels, buckets, and tanks. If this cannot be done, pour cooking oil on the water surface. Punch holes in all tins, plastics, and beverage boxes to prevent the collection of water before disposal. Cover all tires or fill with dirt to prevent water collection. Scrub all vases once per week to remove mosquito eggs. Use mosquito repellents to protect yourself from mosquito bites. Dispose of garbage properly by placing in plastic bags and securing properly to prevent water collection.
A message from the Ministry of Health and Wellness.
Jamaica, I can help you protect our citizens.
Jamaica Eye will play a part in increasing your public safety.
Jamaica Eye is part of an island-wide network of camera surveillance systems designed to increase the safety of you, our citizens. If you have a camera system outside your home or office facing a public space, log on to jamaicaeye.gov.jm today. Jamaica Eye, we're all connected. The Ministry of National Security, creating a safer and prosperous Jamaica.
We want a peace for Jamaica. Yeah. We have to be our brother's keeper. Yeah. Jamaica live good, yeah. I make we enjoy life. What we feel safe at night. Jamaica live good. I better you and I. No say we future bright. Jamaica live good. Come together as one. I make the violence the world.
Me, I go show them my way of justice.
I'm abused.
I need legal advice. I don't deserve this.
The truth of the matter is, justice there for all of we. The Ministry of Justice has trained more than 5,600 persons in restorative justice practices. More than 200,000 victims have been supported by the victim services. Legal aid has reached thousands island-wide. Make we talk it out, not fight it out. Call 888 Justice today.
It's Tuesday, July 22nd. In the headlines, Minister of Legal and Constitutional Affairs, Marlene Malahoo Fort, addresses public concerns about the pace of Jamaica's constitutional reform process. In business news, fake Blue Mountain coffee in China. Regionally, new U.S. ambassador to Haiti prioritizes security amid escalating gang violence. And Health Ministry tackles over 1,800 nursing vacancies in Trinidad and Tobago. In sports, West Indies to face Australia in the second T20 international match at Sabina Park. This is the news on PBC Jamaica. I'm Simone Absalom Gale. Minister of Legal and Constitutional Affairs, Marlene Malahoo Fort, has addressed recent public concerns about the pace of Jamaica's constitutional reform process, asserting that significant groundwork has been laid to transition the country into a republic. In a media statement, Minister Malahoo Fort pointed to several key milestones, including the publication of recommendations by the Constitutional Reform Committee, the passage of a bill amending Section 61 of the Constitution, and the tabling of the Constitution Amendment Republic Bill 2024. She described these developments as clear indicators that Jamaica is closer than ever to becoming a republic. However, The minister acknowledges that greater progress might have been achieved with a more unified national approach. She notes that such collaboration could have accelerated the bill's passage and allowed the second phase of reform to begin under the current parliamentary term. Responding to concerns that the Republic Bill may not be debated or voted on before the next general election, Minister Malahoo Fort explains that constitutional timelines govern the legislative process. She outlines a mandatory 3-month waiting period before the bill can be debated, followed by another 3 months before it can be put to a vote. The bill was tabled in December 2024 and sent to a joint select committee in January 2025. However, the committee's work was disrupted when opposition members, including the leader of the opposition, withdrew after the first meeting. Their departure was in protest of the government's decision to delay discussions on Jamaica's final appellate court, a matter slated for the next phase of reform. Minister Malahoo Fort emphasizes the current phase of the constitutional reform is still ongoing. 86 Jamaicans received their land titles in Westmoreland recently from the Housing Agency of Jamaica, HAJ. Speaking at the handover ceremony, Member of Parliament for Westmoreland Central, George Wright, said the handover is a great moment for Jamaica as these families in Westmoreland now own their own land. He acknowledged the work done by the HAJ to make this opportunity possible.
Today we gather to celebrate a milestone in our nation's journey towards providing shelter and security for all. The Housing Agency of Jamaica has been the forefront of this endeavor, working tirelessly to address the pressing issue of land tenure and housing for thousands of our citizens.
Prime Minister Dr. Andrew Holness, in his remarks, said the occasion marked the vision of his administration to expand home ownership in Jamaica.
We are here to advance a vision of broad-based land and home ownership in Jamaica. 86 of you from the communities I've just named, namely White House, Whitehall, Land Isle, Seaton Crescent, Galloway, and Hermitage in Betheltown, will walk away from this ceremony with a document that has eluded you and many others for far too long, a certificate of title.
He says the HAJ has over 7,000 titles ready. They're only able to give out 50 of those titles as some people still owe money. In other instances, lands need to be resurveyed, causing less titles to be ready.
For the people who are benefiting, it's remind me, Doreen, how many titles in all you have? You have 50 titles here, but how many in all you have? Over 7,000 titles, and I'm gonna say some things about that. So we could make 7,000 families titled. But some of you owe some money.
The Ministry of Health and Wellness continues to work on its electronic health record system, the EHR system. The EHR is a digital version of a patient's medical history maintained over time by a healthcare provider and can be shared across various authorized healthcare centers. Jamaica's electronic health records system is now active at the Mapen Hospital in Clarendon. Dubbed eCare, the system is part of a public health overhaul that modernizes service delivery through implementation of digital health records. We have more in this report.
The digital transformation of Jamaica's public health sector is progressing, and a key component is the implementation of an electronic health record EHR system.
Electronic health record system, System 1, or SI for short. When the patient comes for registration process, we would input the data on S1, and then this data will come around to wherever the doctor is or the nurse is. So they do not need to be waiting on health records to go and retrieve the paper record to bring to them. And if the patient comes with any investigation with the blood results, X-ray, any form of laboratory results or any external result, we would upload those at the time of registration. So when they come to the doctor and the nurse, the information is readily available.
Doctors will be able to see diagnostic scans on their computers and tablets remotely.
Right, and it also allows multiple persons to be retrieving the data simultaneously, or we can do data entry simultaneously.
You can actually measure time from arrival to time of triage, and thereafter every interaction with every member of staff is actually timed. So it is good for tracking, whereas the previous system, if the doctor or the nurse never actually wrote the time that they were seeing, it doesn't get tracked as easily.
It's a shift from paper-based health records management that is allowing improved patient care coordination, enhanced data accuracy, and better decision-making by medical personnel.
Names come up on the system, and as they are seen, there's a color change, so you know which one is seen by the nurse, which one is already seen by the doctor, which one is discharged. So each one of those, if there's no color change, you know that person has not yet been seen. So in terms of efficiency, that's excellent.
The EHR is being implemented by the Ministry of Health as part of the Health Systems Strengthening Project, valued at over $5 million. The EHR allows for not just patient registration, but also appointment scheduling and patient assignment in the triage process.
I know that for the outpatients department, definitely throughput is much faster, and the chance of people getting missed or neglected in the clinic is almost nil now.
The system, which is intended to go island-wide, is being initially rolled out in 13 health facilities over an 18-month period. Maypen Hospital was the first to operationalize the electronic health record system.
The reason why we were the first, I think, is because we were the most ready to receive and accept such a new system.
The first phase rollout will also include the Chapelton, Spanish Town, and St. Anne's Bay hospitals, as well as the Maypen West, Maypen East, and St. Jago health centers.
In this week's Living Healthy report, we hear from a psychiatrist at Jamaica's public psychiatric healthcare facility, Bellevue Hospital, Dr. Brian Kazara, on mental health in the workplace. Dr. Kazar, in your experience, how does stress affect your mental health at a workplace?
Great question. So when it comes to workplace stress, there are a couple factors. One is work culture. So if you're in an office environment or a workspace where your boss is very demanding or, unfortunately, maybe very disrespectful to you, that can of course be a great source of stress. If you're in a workspace environment where you feel like some persons get away with some things and others don't, that is something that a lot of people have over the years described being a particularly frustrating thing to have to deal with, right? If you feel like you're in a workspace where you have to always be walking on eggshells because the boss or colleague may explode at the slightest thing. If you feel like you're in a vindictive environment where even anything that could be perceived as a slight can be used against you. You don't feel free to speak, you don't feel free to talk. If it's a situation where you feel as though you don't, regardless of how much effort you put in, it's not really going to make a difference in terms of maybe your valuation, your prospects of promotion, things like that. There are some cases where, unfortunately, we know that people aren't necessarily getting some of the payments that they should be getting. They might be working overtime and the overtime isn't signed for. They may not be getting paid on time. So payment issues are a whole other section of stress that a lot of people can relate to. There might be significant pay delays And we see that all the time. So those are some things that would contribute to stress in the workplace. Another thing that would contribute to stress in the workplace is long hours, and especially when sometimes these hours are very unpredictable. So there's this unwritten rule in many workplaces in Jamaica that, you know, if you just have to stay back an extra 2-3 hours, you just have to stay back. Right? And this can be regardless of what responsibilities you might have for younger children, your own personal commitments that you might have made. It's just somewhat expected, and that can also be really, really difficult and frustrating for someone to have to deal with. Aside from just work culture, interpersonal tensions in the workplace are common, very common. Patients come and tell me about that all the time, because the reality is that you're dealing with people from different backgrounds, different stages of life, going through different experiences at that point in time. And sometimes people carry some of their stress from home to work. And so you do find that that kind of interpersonal tension is also a frequent cause of workplace stress. So those are some of the things I would say contribute to workplace stress and then reduce productivity, because now your attention is no longer solely on work. You're trying to figure out how you're going to navigate office politics. You're trying to figure out how you're not going to offend the boss, or how you're not going to upset the person that you're working right next to. You may, in fact, because you're so stressed, we know that when stress is significant, it does affect your ability to be attentive, to be able to concentrate. So that's another area. And of course, if all of these things are affecting your mood negatively, if you feel you have a very low mood, you're going to be less motivated. So a lot of times employers will hope that the persons that are working with them will go the extra mile. It's much harder to go the extra mile when you're not motivated. So that's another way that it can affect performance. There's this term that we're using, hopefully I'm quoting it properly, it's become quite popular, which is, I think it's called silent quitting. Hopefully I'm saying it right. And that whole idea is that you already are dissatisfied with your situation in the workplace. You're not going to put in any more effort than the bare minimum required to just ensure you do the basic tasks, right? But you're not necessarily going to go any higher, and part of that comes from this frustration that regardless of what you do, you might be treated unfairly, you may not get what you deserve, or you may still have to deal with these ongoing issues. So these are some ways in which workplace stress can actually contribute to reduced productivity in the workplace.
Time now for the business report with Denise Williams.
Welcome to today's Business Report. I'm Denise Williams, here to bring you the stories shaping the financial world and guiding your journey to smarter business decisions. Let's dive into the top headlines. President of the Jamaica Coffee Exporters Association, Norman Grant, is moving to address concerns about the piracy of Jamaican Blue Mountain coffee in China. Mr. Grant, who also heads the Mavis Bank Coffee Factory, says he's working to convene a high-level meeting next week with stakeholders, including the Chinese ambassador to Jamaica, Jamaica's ambassador to China, and officials from the Ministries of Foreign Affairs and Agriculture, as well as the Jamaica Commodities Regulatory Authority. The aim is to tackle the growing issue of counterfeit Blue Mountain coffee appearing in the Chinese market. Caribbean Cement Company says it plans to export 28,000 tons of cement to Caribbean markets starting next month. It follows the recent completion of its US $42 million expansion plan. Managing Director Jorge Martinez tells RJR News that the plan will see a 150,000 ton expansion in production to 1.15 million tons annually. He added that the company generated revenues of $27.9 billion last year, despite the fall in annual output to 950,000 metric tons due to the plant shutdown. The company also indicated that it generated net profits of $2 billion on revenues of $8.2 billion during the first quarter of this year, compared with $1.9 billion on revenues of $7.6 billion for the comparative period last year. for the trading period ending July 21, 2020